Troy James Ollis, you have pleaded guilty to 7 charges of sexual penetration of a child, aged 16 or 17, under your care, supervision or authority. These are charges 1 to 7. 1 charge of producing child abuse material, charge 8, and 1 charge of possessing child abuse material, charge 9. For each charge, the maximum penalty is a term of imprisonment of 10 years. Charges 2, 4, 6, 7 and 8 are rolled up charges. Exhibit 1 on the plea was an agreed summary of prosecution opening, setting out the detailed facts of your offending. In brief, the circumstances of your offending were as follows. On the 14th of January 2025, you arrived at Melbourne Airport, returning from a family trip to Tanzania. Your Apple iPhone was examined by a Border Force officer. In a hidden folder on that device were multiple files of a girl who appeared to be under the age of 18, performing sexual acts with you. Upon questioning, you confirmed that the girl so depicted was Shayla Green, a student from the school at which you taught, and that you and she would meet up about once a month during the second half of 2024 to have sex. You stated, quote, "My life is over now, isn't it?" unquote. Shayla was contacted and provided a VER on the 16th of January 2025. In that VER, she stated that you and she had been engaged in an ongoing sexual relationship. She had engaged in various penetrative sexual acts with you on multiple occasions at hotels, at your home address, and in your vehicle. You had often filmed these encounters, this is charge 8, with her full knowledge and consent. She refused to discuss details of your offending, but confirmed that the video files created by you were an accurate representation of your sexual interactions. She stated you always met during the day and that she had never spent the night with you. She stated multiple times that she was aware that your relationship was illegal, but that as she was age 16 and of the age of consent, the only problem was that you were her teacher. Analysis of your device and Shayla's timeline enabled the charge offending to be identified. The immediate context for this offending is that when you were Shayla's English teacher, you began to communicate outside of class, initially on the school email system. Prior to her 16th birthday, you complimented Shayla on her writing style, maturity and work ethic, sending her copies of your own writing and seeking feedback from her. You described her as your most promising student and encouraged her to meet with you one-on-one to discuss assessments. You then began chats on Google Docs outside of school. You would delete these chats, however. Some were saved by Shayla and were accessed by police. They reveal explicit discussions of sex between you and Shayla and concerning sexual fantasies involving other children. You bought Shayla a phone so that she could communicate with you and avoid the strict parental control settings on her own phone. The phone was bought and registered before the charged offending began. On Sunday, the 1st of September 2024, you met at a hotel in Maribyrnong. You penetrated Shayla's vagina with your penis. This is charge 1. The offending is captured on your device, as you filmed both the act of sexual penetration and other intimate moments, part charge 8 and 9, and kept the files in the hidden folder. On Sunday, the 15th of September 2024, you and Shayla met in your vehicle. You picked Shayla up from near her home address and then drove to a secluded location. Her parents believed that Shayla was going off to work. Once the vehicle was parked, you penetrated Shayla's vagina with your penis, both without and with a condom, and also caused Shayla to penetrate her anus with a butt plug. This is charge 2, a rolled up charge. Paragraph 27 of Exhibit 1 sets out in detail the images and files located on your phone of the sexual interaction that you filmed on this occasion, part charge 8 and 9. The files include explicit images of Shayla's genitals, including with a butt plug in her anus, your penile penetration of her vagina, including Shayla's concern that you may get her pregnant, dominant role play, and breath play, strangulation. At one point, you were clearly heard to say, "I hope no one ever sees this video." On Friday the 4th of October 2024, you again met in your car where you digitally penetrated Shayla's vagina, charge 3. Paragraph 30, Exhibit 1, sets out in detail the images and files located in the hidden folder on your phone, part charge 8 and 9, created on this day. Again, explicit images of Shayla's genitals, the act of digital vaginal penetration, dominance, daddy-girl roleplay, and ejaculate down the side of Shayla's face, running into her mouth. On Saturday the 23rd of November 2024, you and Shayla were in a room at the Mantra Hotel, Melbourne Airport, where you engaged in both digital vaginal and penile vaginal penetration of Shayla. This is charge 4, a rolled up charge. Paragraph 33 of Exhibit 1 sets out in detail the images and files located in the hidden folder on your phone, part charge 8 and 9, created on this day. In addition to both the charged acts of sexual penetration, the files include explicit images of Shayla's vagina, the insertion of your finger direct from Shayla's vagina to her mouth, daddy baby girl roleplay, and physical chastisement. On Sunday the 24th of November 2024, you and Shayla were at your home address where you penetrated her vagina with your penis, charge 5. Paragraph 37 of Exhibit 1 sets out in detail the images and files located on your phone in the hidden folder, part charge 8 and 9, created on this day, including images of Shayla naked and of her vagina exposed to the camera, in addition to the charged act of penetration. On Sunday, the 8th of December 2024, you and Shayla were again together at your home address, where you performed oral sex upon Shayla and then penetrated her mouth with your penis on multiple occasions. This is charge 6, a rolled up charge. Paragraph 40 of Exhibit 1 sets out in detail the images and files located in the hidden folder on your phone, part charge 8 and 9, created on this day, including all of the charged acts of penetration. Paragraph 40, subsection 6 of Exhibit 1 notes, the video ends with the offender forcing his penis into the victim's mouth while she chokes and goes red in the face, unquote. It may be that this is dominant submissive roleplay. The child abuse material created depicts coerced penile oral penetration. On Sunday the 15th of December 2024, you and Shayla were again at your home address where you penetrated Shayla's mouth with your penis and caused her to penetrate your anus with her finger and tongue, charge 7, rolled up charge. Paragraph 43 of Exhibit 1 sets out in detail the images and files located in the hidden folder on your phone, part of charge 8 and 9, created on this day, including all the charged acts of penetration. Shayla is seen performing oral sex upon you and masturbating you. You are directing the anal penetration of yourself with dominant submission roleplay. At one point, Shayla has the camera on you and asks, quote, "You're my teacher, aren't you ashamed of yourself?" unquote. You reply that you are not ashamed and love being anally penetrated by her. Analysis of your iPhone located 20 Category 1 and 120 Category 2 child abuse images, and this is charge 9. Many images were of Shayla, not all of which were created on the occasions of the charged offending. See paragraph 55 of Exhibit 1. In total, there were 71 child abuse files of children other than Shayla, including images of very young children engaged in penetrative sexual acts with adults. See paragraph 52 of Exhibit 1. Phone analysis also revealed that you sent a video file depicting you engaged in an act of sexual penetration with Shayla to a WhatsApp chat with a Kenyan area code. On the 2nd of January 2025, when you were on your family holiday in Tanzania, you sent a message stating, quote, "Hee hee, I have lots of videos and photos with this girl. She loved being on camera with my dick, unquote. You were also a member of various Telegram chat groups expressly interested in adolescents under the age of 18. See paragraph 50 of Exhibit 1. You were bailed following interview. A filing hearing was heard on the 22nd of January 2025 and resolution discussions commenced. The matter resolved at the third committal mention in August 2025. Yours I will regard as a plea of guilty entered at the earliest opportunity. Exhibit 3 was a victim impact statement from Shayla's parents, Robert and Tanya. They speak in compelling terms of the impact of your offending upon their family, upon their relationship with their daughter, the shame and humiliation they felt as knowledge of your offending leaked out into the school community, and the consequent depression that both had suffered. Exhibit 4 was a victim impact statement from Angela, Shayla's younger sister, who speaks powerfully of her sense of loss of the secure family, of her relationship with her sister, and loss of the comfort of acceptance at school. Now, whilst victim impact statements must not be permitted to overwhelm the sentencing process, there can be no doubt as to the traumatic and enduring impact your offending has had. I should note that Shayla has not provided a victim impact statement and is concerned, I understand, to make clear that she does not feel herself to be a victim, but rather had agency and autonomy throughout. I now turn to your personal circumstances. You were born on the 12th of March 1991 in Portland, Victoria. You have no prior or subsequent criminal matters. You grew up in Geelong and its surrounds. You were the second child in a sibship of 3, with an older brother and a younger sister. Both your siblings were born with serious disabilities. Your sister, with whom you had a close relationship, passed away from muscular dystrophy when she was 4 and you were 7 years old. You describe having a complicated relationship with your brother, but that you remain close. You were a healthy child, and thus you received less attention from your parents than your siblings. You report a childhood perception of being unseen and lonely due to the ill health of your siblings. You said that while you never felt consciously neglected, you experienced a lack of attention. You appear to have some guilt that you were not born with a disability. See Exhibit 6TO. After your sister passed away, your father turned to alcohol as a coping mechanism, resulting in frequent outbursts of temper and frequent parental arguments. You wished that your parents would separate so that there could be some peace in the home. Your parents thereafter converted to Christianity and adopted, quote, strict religious values and expectations, unquote, with discipline consisting of long handwritten letters filled with Bible verses expressing their disappointment in you. While your parents remain devout Christians, you report that their faith is not as all-encompassing as it previously was, and you continue to have a good relationship with both your parents. You state that you have again found faith in response to the criminal process. At primary school, you were socially isolated with only one friend. At secondary school, you struggled to fit in, experiencing verbal and physical bullying, and on one occasion suffered a fractured cheekbone. Your sense of familial isolation was thus reinforced. You completed VCE, but described yourself as a lazy student who did not perform well. After year 12, you took a gap year traveling to India and the United States for various missionary-related trips and internships. You enrolled in a bachelor's degree in creative writing and journalism, which you did not enjoy or complete. You then completed a double degree in arts and education and became a qualified secondary school teacher. Your sense of being overlooked was the driving force behind your desire to become a teacher. During your studies, you worked as an online tutor, which you described as one of your favorite jobs. After graduation, you began working as a teacher at a secondary school for 2 years and were then employed for 3 years at the school where you were when the offending occurred. Your employment has since been terminated once your offending became known. Since that termination, you have been working as an Uber Eats driver and in other delivery-based jobs. You reported prolonged sexual abuse at the hands of an older male relative. This has not been discussed further during post-offence treatment, and on the material in front of me does not appear to be a significant factor in your offending. You have expressed a desire to address your own experience of childhood trauma in future sessions. Your first sexual partner and only significant relationship was with your now wife, whom you met in 2013 and married in 2017, and with whom you have a son, now aged 4 years. Your wife's history of trauma and abuse has had a serious impact upon your marital relationship, with intimacy being occasional at best. She does, however, remain steadfast in her support of you, as do your parents, your surviving brother, and other friends. See Exhibits 8TO to 16TO. You began viewing pornography as a child, and by your 20s you accept that you were addicted to pornography, often viewing such material for approximately 2 hours per day. In terms of your substance use, you reported drinking alcohol socially, approximately every second weekend, and you have never been a daily drinker. You also used cannabis at the age of approximately 22, but have never been a daily user and ceased using the substance around 4 years ago. And you have never used any other illicit substance. Exhibit 6TO was a psychological report from Dr. Michael Davis, forensic clinical psychologist, dated the 7th of November 2025. Exhibit 7TO was a treating psychologist report from Dr. Rachel Mackenzie, dated the 5th of November 2025. Dr. Davis, in his extensive report, noted that you have had a seemingly high sexual drive since your teenage years, and also your self-identified addiction to pornography. During the course of your marriage, sexual intimacy between you and your wife had effectively ceased. You had, however, engaged in multiple casual sexual encounters with both males and females. See paragraphs 66 and 67. Dr. Davis was of the opinion that you met formal criteria for several interacting diagnoses, including a depressed mood falling short of a major depressive episode, and avoidant personality disorder, with some dependent and schizoid personality features which, quote, while not meeting formal criteria for any further personality disorder diagnoses, nonetheless contribute to the often maladaptive way that he views himself and interacts with the wider world. It is my opinion that his personality function is currently at a moderate level of impairment, unquote. Further, he also meets formal criteria for compulsive sexual behavior disorder. Indeed, hypersexuality, compulsive pornography use, and excessive masturbation appears to have been present from a rather young age, unquote. Dr. Davis noted concerningly that whilst you are currently trying to limit this behavior, you continue to masturbate and watch pornography on a regular basis. Whilst you did not meet the criteria for a paraphilic disorder, i.e. a settled sexual preference for prepubescent or pubescent children, Dr. Davis noted, quote, it is perhaps clear that he has a sexual attraction to adolescents, ephebophilia. While acting on a ephebophilic sexual interest is clearly illegal at the lower age range of adolescence, ephebophilia is not considered sexually deviant in a diagnostic sense. After referring to the scholarly conceptualization of child molestation offenders as being on a continuum from the situational and impulsive to the preferential and compulsive, he states, quote, it is my opinion that his sexual offending behavior places him more towards the situational end of this continuum and is best explained by reference to an inadequate pattern of behavior. He was an inadequate man with avoidant personality disorder, compulsive sexual behavior disorder, and chronic difficulties with depressed mood. He was in a marriage that had little in the way of sexual intimacy. Mr. Ollis wanted someone to admire him and to really desire him sexually. The sexual interest and emotional congruence with the victim resulted in continued gross violations of professional boundaries and ultimately a sexual relationship that appears to have involved a variety of fantasy role plays and text-based fantasies of taboo topics. Indeed, he admitted that the victim made him feel more wanted than anyone ever had. As such, the attention, praise, and sexual interactions served to salve his insecurity and inadequacy. The small collection of child abuse material that did not include the victim of his contact offending is likely to reflect the indiscriminate viewing and downloading of pornographic material during lengthy hypersexual masturbation sessions. Unquote. However, the fact that they were not deleted is of some concern. Dr. Davis assessed you currently as a low to moderate risk for contact sexual offending and as a moderate risk of further child abuse material offending. Quote, while he remains a rather hypersexual individual with a complicated and sexually unsatisfying marriage, it is difficult to identify a further scenario in which he may commit further contact offending. He is socially inadequate, man who is able to develop a sexual relationship with the victim in the context of being a teacher. He will never be in such a situation again. Unquote. Dr. Davis did not recommend further offence-specific treatment, and certainly not in any custodial group setting. He recommended clinical treatment to address your long-standing depressed mood, childhood trauma, your hypersexuality, and avoidant personality disorder. He had some concerns as to your ability to cope with prison life. Quote, his mental state is likely to deteriorate to some extent as he has a lengthy history of dysthymic and depressed mood. Moreover, I am of the view that it is somewhat unusual interpersonal style for making a potential target for victimization, and he is unlikely to speak up should that occur. Accordingly, he will need regular contact with mental health services. Dr. Mackenzie's report, Exhibit 70, did not address your risk of future offending. At the time of writing, you had attended Dr. Mackenzie for 14 treatment sessions remotely via telehealth. You presented as articulate, softly spoken and reserved, and appeared of average intelligence, although not formally tested. Your initial elevated scores for depression and anxiety have slowly reduced over the course of treatment. Dr. Mackenzie recounted your personal history. She noted that you have expressed a desire to address your own experience of childhood trauma in future sessions. You had no significant medical or substance use history and no past mental health diagnoses. Your self-reported symptoms of chronic stress going back to childhood would likely have met the criteria for a depressive or anxiety disorder. Whilst at the start of treatment, you met the criteria for a major depressive disorder due to the impact of this offending upon you and your family, Dr. Mackenzie was not of the opinion that you currently meet the criteria for any psychiatric condition. Your initial elevated scores for depression and anxiety have slowly reduced over the course of treatment. Dr. Mackenzie, as with Dr. Davis, did not diagnose a paraphilic disorder. Rather, quote, it appears that his offending has been opportunistic and has arisen out of a dysfunctional attempt to bolster his self-esteem by gaining the attention, validation, and sexual gratification that was lacking in his marriage. The small number of child abuse images found in his possession do not indicate a pattern of specific sexual arousal or interest in underage children per se. Treatment goals included identifying the needs that were being met by and challenging the cognitive distortions that enabled your offending, establishing victim empathy, and developing relapse prevention strategies. Dr. Mackenzie describes you as well-engaged and active participant in the treatment sessions. You've accepted the harm you may have caused and appear to be genuinely remorseful, although assessment of remorse was outside of her professional opinion. You have demonstrated clear progress in treatment. Dr. Mackenzie did not believe that a term of imprisonment would have a significant detrimental impact on the specific therapeutic progress that you have clearly made. Ms. Caruso, Learning Counsel on behalf of the Director, submitted that your offending was objectively very serious, constituting inherently a grave breach of trust. From charge 3 onwards, by virtue of the serious offender provisions, community protection would be the primary sentencing principle, with general deterrence otherwise the most significant sentencing principle. Denunciation and just punishment were also important sentencing considerations. Specific deterrence also had work to do. The statutory presumption of cumulation must be balanced with the need to ensure a sentence that is just and proportionate. The only appropriate sentence was a head sentence and a non-parole period. Ms. Benchich, learned counsel on your behalf, conceded that this was objectively very serious offending for which your moral culpability was high. General deterrence, denunciation, just punishment, they were all primary sentencing purposes. And in addition, specific deterrence and community protection had work to do. She accepted that a head sentence and non-parole period was warranted. However, in mitigation of such sentence, she submitted. The offending was situational. That is, you did not set out to deliberately groom your victim. This was initially an intense but appropriate teacher-student relationship. A gifted teacher intent on nurturing writing talent, interacting with a gifted student. The crossing of boundaries and the offending was driven by the way that your victim made you feel. Your victim gave you something that your casual sexual hookups did not, echoed in the report of Dr. Davis, Exhibit 6TO. She submitted there was an absence of aggravating features so often found in offending of this kind. There was no violence over and above the role play, which she conceded represented a form of degradation and humiliation. There were no inducements. There was no coercion over and above the power imbalance inherent in a teacher-pupil relationship. Indeed, over and above the vulnerability inherent in a child, there was no particular vulnerability in your victim, although she conceded you may have known that Shayla had some issues with her family home life. She submitted the offending did not take place in school hours, on campus, or at school premises. The offending lasted for a period of no more than 3.5 months. She recognised that the failure to use a condom was an aggravating feature of charge 2. However, she was clear no such finding was open on any of the other charges. As to charge 8, the production of child abuse material, she conceded it fell in the upper end of mid-range of seriousness. The use of sex toys, strangulation, and domination role play was, she accepted, an aggravating feature of the offending. It was open, she conceded, to view your sharing of an intimate image of Shayla as an aggravating feature of that charge. As to charge 9, she reminded me that there was only a small number of files that were not of Shayla, and there was accordingly a need to avoid double punishment. She submitted that you may not have known that the Category 1 child abuse material was present on your device and asked me to consider that it may have been downloaded in the course of Telegram chats in a cache of files. She submitted correctly that notwithstanding the statutory presumption of cumulation for charges 3 to 9, totality and proportionality remain significant considerations. Your plea of guilty was entered at the earliest opportunity, after the matter resolved. This demonstrated not only a willingness to facilitate the course of justice, but also an acceptance of responsibility, and she submitted a demonstration of your remorse. She submitted further that you are remorseful and that it is difficult to conceive what more you could have done since your arrest to foster your rehabilitation, pointing to your engagement in treatment and on working through relationship issues in your marriage. She submitted your prospects for rehabilitation were excellent, having regard to your absence of prior or subsequent matters, although accepting that less weight might be given to prior good character in offending of this kind, to your solid and consistent work history, your early plea of guilty and acceptance of responsibility, the progress made in treatment, your low risk of reoffending as assessed by Dr. Davis, and your continued family support as witnessed by Exhibits 8 TO to 16 TO. She also urged me to give weight to the extracurricular punishment that you have endured, namely the loss of your career, the loss of access to your child, and the public condemnation to which you have been exposed as a result of the widespread reporting of this matter. Your time in prison, she submitted, will be more burdensome for you than for someone without your mental health challenges, and there is a significant risk of a deterioration in your mental health. You will keenly feel the loss and separation from your family during your time in custody. She urged a parole period that would provide you with an opportunity of being released with support into the community. Mr. Ollis, this is serious offending, as is made plain by the maximum penalties that Parliament has seen fit to impose. Charges 1 to 8 are serious examples of such offending. The prohibition of sexual intimacy with young people under the care, supervision, or authority of another is designed to protect young people from sexual exploitation by those who have particular authority over them. I note that Shayla does not at this point see herself as a victim and claims agency. It may be that as she matures, she will view matters differently. Howsoever, there is a presumption of harm arising regardless of the fact that the young person may consent to sexual activity. There is both a particular authority and a particular trust that attaches to the teacher-pupil relationship. The role of a teacher is a highly valued and influential one. A teacher may have immense and lasting impact upon the young minds in their care. But with that authority comes responsibility. A teacher should always act in the best interests of their students and always behave in a professional manner towards them. The young are inherently vulnerable. Access to them and to their developing minds is a privilege that must not be abused. Personal interests and desires must never be permitted to enter into or pervert, corrupt, or corrode the teacher-pupil relationship. I accept that the extracurricular engagement with Shayla may initially have derived from a wish to nurture her talent. However, boundaries were crossed, and you betrayed the trust placed in you in the service of your own desires. A breach of trust is inherent in this offending. The pathway for this offending is not, in my view, adequately identified in the reports of Dr. Davis and Dr. Mackenzie. Your offending is framed by them in terms of a need for validation. Now, whilst there was a lack of intimacy in your marriage, you were not, I find, a sexual naive, but rather sexually experienced and able to navigate the world of casual sexual hookups to find and explore all aspects of your sexuality with sexual partners of either gender. See paragraphs 66 and 67 of Exhibit 6TO. Thus, you could gain validation in your online hookups. You offended over 3.5 months, 3.5 months, I should say, because you simply gained sexual satisfaction from it, as your membership of various chat groups makes clear. You were resolved upon your own desires and sexual needs and were heedless of the potential detrimental and adverse impact that fulfilling those needs may have had upon your victim. Your moral culpability for this offending is high. The rolled up charge, too, includes an instance of penile vaginal penetration without a condom, which is an aggravating feature of that offence. All the sexual interactions were recorded, charge 8, apparently with Shayla's consent. The child abuse material thus created captured sexual interactions that were, on any view, very graphic in nature, dealing as they do in domination, other role play, and breath play. But instead of holding the images of your intimacy in a private place, as I am sure Shayla would have wished you to do, you shared an image. The accompanying words, which I do not repeat, make clear that you not only abused the trust of a child who was under your authority, but reduced her supposed maturity, love, and sexual preparedness to a trophy, a conquest of which you boasted. This is the validation that you obtained, and the sharing of that image is an aggravating feature of that offence. Now, those who possess child abuse material to any degree are bad actors in the industry of abuse of children. They are customers, and without customers, there would be no market. A market that is based upon a fundamental betrayal of our common humanity by the degrading and traumatizing exploitation of children for the sexual gratification of others. The term of imprisonment will almost inevitably be imposed for those who come before the courts. I accept that the number of files, not of Shayla, which are 71 in total, was certainly not as extensive or as numerous as is so often encountered in the court. I also accept there appears to be some uncertainty as to whether you had viewed all of the child abuse material which may have come to you as part of an open download. However, some of the Category 1 images were of a most depraved nature. Now, Mr. Ollis, in sentencing you, I must have regard to a range of different factors. I must give effect to the principle of general deterrence, that is, to deter others from behaving as you did, and to specific deterrence, that is, to deter you from ever repeating such offending. I must consider the need to protect the community. I must express the community's denunciation of your conduct. I must take into account the effect of your crimes upon your victim. I must have regard to current sentencing practices and the statutory maximum penalties for the offences to which you have pleaded guilty. I must also ensure, as far as possible, that you are rehabilitated and reintegrated into society. In short, I must try to balance your personal circumstances with the circumstances of your offending. I must also pass no greater sentence than is necessary in all the circumstances of the case, as I find them to be. I must impose a sentence that is just in relation to the totality of your offending, as described by the particulars in the indictment and set out in the opening, in relation to the detail of the incidents of offending. It is not in dispute that because you are to receive a custodial term on charges 1 and 2 on the indictment, you fall to be sentenced as a serious sexual offender in respect of charges 3 to 9. The law requires that I regard protection of the community as the principal purpose for which the sentence is imposed in respect of those charges. Section 6E of the Sentencing Act also prescribes that there is a presumption that sentences imposed on those charges should be served cumulatively, unless otherwise directed by the court. The prosecution indicated they did not seek a disproportionate sentence in respect of those charges, but such provisions must also be considered in conjunction with the totality principle of sentencing, as recently referred to by the Court of Appeal in the Director versus Dillon, a pseudonym, 2025 VSCA 266, paragraphs 59 to 68. In addition to community protection, there is a primary need for general deterrence and denunciation in dealing with offending of this kind. Schools must be safe places for students. Pupils must not be reduced to the sexual playthings of their teachers. The offending in charges 1 to 8 flew in the face of those simple propositions with lasting and traumatic consequences for your victim's family. Whilst you may not have access to young people in the future, there is still a need, I find, for specific deterrence to play a role. I've had regard to all of the matters urged upon me by your counsel. In particular, I've had regard to your plea of guilty. Entered, I accept at the earliest opportunity, bringing with it the practical benefit of saving the community the time and expense of a trial and saving witnesses from the trauma of giving evidence, and as an indication of your willingness to facilitate the course of justice. I accept that you are remorseful and have worked hard in treatment to understand your offending, and I accept that you are developing insight. I accept that you will keenly feel the separation from your family whilst in custody. I give such weight as I can to the extracurricular punishment to which you have been exposed. I accept that in your case, propositions 5 and 6 of Verdens are enlivened. I accept that there are considerable grounds for optimism as to your prospects for rehabilitation. I accept that I must be astute to avoid double punishment and must have regard to the principle of totality. Nonetheless, as your counsel has conceded, and as you must be well aware, the objective gravity of this offending is such that it can only be met by a substantial term of imprisonment. I have moderated sentences and orders for cumulation in the interests of proportionality. On charge 1, you are sentenced to a term of imprisonment of 2 years and 6 months. On charge 2, you are sentenced to a term of imprisonment of 3 years and 10 months. On charge 3, you're sentenced to a term of imprisonment of 2 years and 8 months. On charge 4, you're sentenced to a term of imprisonment of 3 years. On charge 5, you're sentenced to a term of imprisonment of 2 years and 10 months. On charge 6, you are sentenced to a term of imprisonment of 3 years and 4 months. On charge 7, you are sentenced to a term of imprisonment of 3 years and 4 months. On charge 8, you are sentenced to a term of imprisonment of 3 years and 6 months. And on charge 9, you are sentenced to a term of imprisonment of 5 months. I order that 2 months of the sentence on charge 1, 3 months of the sentence on charge 3, 4 months of the sentence on charge 4, 4 months of the sentence on charge 5, 5 months of the sentence on charge 6, 6 months of the sentence on charge 7, 12 months of the sentence on charge 8, and 1 month of the sentence on charge 9, run cumulative to each other and cumulative to the sentence on charge 2. This makes a total effective sentence of 6 years and 11 months. I fix a non-parole period of 4 years and 2 months. Pursuant to section 18, subsection 4, I declare of the Sentencing Act, I declare that you have served 68 days of the sentence I have passed upon you, and direct that this be entered into the records of the court. Counsel, I should have checked. Is that an agreed figure?
We agreed on 67, not including today.
67. I shall amend that accordingly. Thank you, Ms. Benchich. Pursuant to section 6AAA, had you not pleaded guilty, you would have been sentenced to a term of imprisonment of 9 years and 9 months with a non-parole period of 7 years. Now, pursuant to the provisions of the Sexual Offender Registration Act, you're now a registrable offender, and the period of registration is for the rest of your life.